Welcome you all to the lecture series on corporate law. This is the third lecture which I am recording and putting forth before all of you. Previous two introductory lectures and the second lecture is on the Memorandum of Association. We have discussed about the incorporation of the companies, how the companies can be incorporated, then the foremost important document, that the contents of MOA. Now after the MOA, the another important document which has to be carried is the Articles of Association. So if you are incorporating a company, you require two documents which have to be carried and to be submitted to the Registrar of Companies. These two documents are MOA and the AOA. Now let us see the importance of AOA and what are the legal aspects, how far a law student or the people who are reading the company law should understand the importance of the Articles of Associations, because the Articles of Association are the part and parcel of the company law. So now let us discuss about the main concepts or the main components of the Articles of Association, because Articles of Association itself is a big document where one has to read and understand when you try to interpret and apply the principles of company law in the practical life, or not only the practical life, in the day-to-day management of the companies. Now what is meant by Articles of Association? In a simple word, what do you mean, or what is the meaning of the AOA? And AOA is defined under Section 4 of the Companies Act. Articles of Association shall contain the regulations for the management of the companies. Now the fundamental question which arises to all of us is that if the Companies Act 2013 is existing to regulate the company, right? Companies Act 2013 is to regulate the companies, right? This is what we are all reading, company law. Now apart from the Companies Act 2013, Articles of a company, that means a document prepared by the founding members or the promoters of the company, which otherwise we call it as Articles of Association, it contains the regulations for the management of the companies. That means there are two documents, or the two legal documents which I can say to regulate the management of company. The first and foremost document is the Companies Act 2013. The other one is Articles of Association. Because Articles of Association is such a free, or which has the freedom to draft the mechanism which you require, or the purpose which you require, the purpose in the sense called how the company has to be managed yourself. Now let me talk, sir, exactly what is this regulations of the managements. In the management, when you look about the management, it means like the voting rights of the shareholders, appointment of the directors, removal of the directors, then after the removal of the directors, again you see the disqualification of the directors, then the charges created on the properties of the companies, and so on. There are various aspects which becomes the part and parcel of the management of the companies. So therefore, AOA, which we call it by other way called as bylaws of the companies, right? AOA is called as the bylaws of the companies. So you have the bylaws which are prepared for internal regulations and internal management of company. It is the nature of the company, either public company, private company, and the other type of the company. Then the company can decide what form have to be adopted. The form in the sense, the articles of the company shall be in the respective forms which are there in the table FGHIJ in the schedule 1. So as we have discussed in the previous class, schedule 1, we are having the A, B, C, D tables up to MOA, and from F, G onwards is about the AOA. That means if you are incorporating a company, the members who are incorporating the company should read and should keep in handy the articles of association which are there in the schedule 1 of the Companies Act. So the fundamental thing is that schedule 1 of the Companies Act is part and parcel of the first document when you are incorporating the company. Then you fill up those requirement things, then you will submit to the ROC with the proper document as well as the proper the fee, then the company gets incorporated. Now moving further, and because the company may adopt all the concepts of AOA or may not adopt. That's why they have said in the section 3(4) itself, it is up to the company either to adopt all, right? Either the all, or they may also adopt any of the regulations contained in the companies. Now you may see that, sir, what are those contents are there? So I try to explain the sub-themes or the themes which are there in the articles of association, what the company law provides, and it is generally given to the different companies, maybe the public limited company, private limited company, then you are having the one-person company, public limited company which is not listed company. So like that, the varieties of companies are there. Then articles of association is a document which applies commonly all the companies. If you are a private limited company, you can adopt the one form. If you are the public limited company, you can adopt the another form. So therefore, it is the discretion, right? It is the discretion power given to the founding members of the company that you adopt all the contents or maybe some of the contents of the articles of association. So section 4 of the Companies Act makes very specific, that is articles of the association, and for incorporation of the companies, the another important document which that has to be submitted before the or at the time of incorporation is the AOA. So the two documents which are necessary to submit to the ROC at the time of incorporation, one is MOA, second one is the AOA. Because these two documents has its own relevance when we talk about the application of law. Now moving further, once you prepare the articles, whether you can go for the alteration, as we are already discussing now, the section 14 of the Companies Act talks, once you prepare the articles, right? Once you prepare the articles, at any point of time, you can alter your articles, right? So it is given in the company law under section 14, subject to the provisions of this act. That means subject to the provisions of the Companies Act and conditions as in the memorandum, if any company by special resolution can alter and the effect of the conversions. That means once you have prepared, and these documents can go for the alteration at any point of time subject to the Article 14. The point which I want to make it is that it is not something, the documents prepared by the corporations are always the final in the nature. It can be amended. It can also go for the alteration as and when required, as and when the management of the company thinks of. So if the company thought that we want to change it, they can change it. And the provision is given under the section 14. So if we again recapitulate, section 4 talks about the concepts of the what we can call AOA, and section 14 talks with regard to the alteration. This is the legal concepts which we talks about the articles of association. Now this particular the visual slide which you are seeing, or the visual board, the contents which I read it here, I brought, or I tried to put it, so exactly what is there in the AOA. Most of the time, as a students of law or belonging to other streams of law, the people who are reading corporate law, they don't look into the AOA. They don't study the AOA from the schedule point of view. Generally, they read articles of association is there. That is only for the purposes of the what we can call implementation of bylaws. Or people will read articles of association or the bylaws of the company. Now the question will come, what are these bylaws? Where exactly the problem and understanding of the bylaws will come. Now let me talk a simple concept. When you see here, there is a concept called transfer of the shares. Section 56 of the Companies Act, right? Section 56 of the Companies Act talks about the transfer and transmission of the shares. So there is a law under Companies Act, that is the section 56, which talks with regard to the transfer and transmission of the shares. In addition to the existing provisions, that is, in addition to the existing provisions of the, I'm writing, in addition to the existing provision or a supplementary to the existing provision, the company, say for example, X Limited is being incorporated, the law applicable to the X Limited is section 56. However, the company can take some of the concepts on their own. It's called transfer of the shares under the Articles of Association. The point which I am referring here is that the companies are given the freedom to make their own bylaws and the regulations, and these bylaws and regulations will be binding on the company. Because this is a very, very important concept. In the case of any dispute, if these provisions are not contradictory, right? If they are not contrary to company law, then AOA prevails. Because AOA has an effective like as a provisions of law. We cannot have the clauses, for example, the transfer of shares contrary to company law. You can have additions, supplementary, and the bylaws are there. Some of you may ask, what are these, what call about the complementary additional provisions? Let me tell you one simple example. If we take a transfer of the shares, because shares are the movable property of the company, when the transfer happens between the one person to another person, there are some of the clauses in agreement. If there is a buyer and seller, I am taking a simple example, buyer and seller. So if there is a buyer and seller of the shares, if they put some of the clauses, like for example, the right of first refusal, right of first offer among the buyer and seller, that's what we call as the transferor and transferee. Because the clauses which are developed by the business community, the clauses which are developed by the people involving the management of the company, it has its own understanding of the subject. It is not that, the company itself is a supreme authority of law. The reasons are given. When you are creating a company, you can prepare your own bylaws, you can prepare your own regulations that will make you to understand, to make the internal management of the companies. If you want to keep the ownership with some persons. So the one of the example which I have given is the management rights, for example, by virtue of transfer of the shares. And if we take another example, like for example, what is meant by the variation of the rights? Because everyone fight for a right in company's management. Because how the rights are being divided. We read in the company law, every shareholder is given the equal right. Each shareholder has an equal right. Shareholders have the equal democracy. Whether it is existing in real sense, is there any difference between rights of the variations? As we see the share capital from section 43 and section 47, which talks about the shareholder and the shareholder's rights, right? In company law, section 43 and 47 talks about the shareholders and the shareholders' rights. In addition to this, you can have the different provisions with regard to the difference of the rights. This is where when you see in the movies or the practice, why one family is always having a control and how the rights are being divided among the shareholders or among the management of the companies. The management means is the founding promoters. The promoters of the companies always wish to control the company by having the right with them. Or otherwise, sometimes what may happen, some other party may come and acquire the shares. The other party may control the company. In turn, what will happen? If the other party comes and acquires the shares of the company, then the management of the company will become given to the second parties or the other party who is an outsider. If I put in a simple example, A and B are the promoters of the company, and later C and D join, and C and G acquire the more shares with the intention to overthrow the A and B. In this scenario, A and B can put a clause, always we have the rights, right? Which I put it. A and B who are the promoters, right? Who have the promoting directors. And they want to retain always the management of company with A and B, not C, D, E, F, whoever is coming later part into the management of companies. Like this, I have just tried to give two examples. One is on the transfer of shares. Other one is about the variation of the rights. So whenever you are going to read or we are going to discuss in furtherance of subjects on the company law, on each and every subtopic or sub-theme, it is referred in the articles of associations. I may take one more examples. What is the meaning of the general meetings? General meetings are defined under the articles of association. General meeting is all the extraordinary general meetings except annual general meeting. If you read the whole Companies Act, you don't find the meaning of general meeting except in the articles of associations. So articles of associations are becoming the part and parcel of company law. If you want to be the mastery of company law, if you want to practice the company law, right? If you want to become the expert where someone will consult you after completion of your degrees, right? Reading of the subject of law for getting of the degrees, reading of the subject of law for practicing of the subject, reading of the law for giving consultations, for providing of the opinions. Therefore, it is very necessary that everyone should read the articles of association of the company, which forms part and parcel of the company law. Though we study articles of association is the primary document which has to be submitted to the ROC at the time of incorporation. It contains lot of bylaws. To name one by one, right? Number one is a law relating to the share capital and law relating to the lien and call on shares, transmission of the shares, forfeiture of the shares, alteration of the shares, and capitalization of the profits. So there is a lot of subtopics on the share capitals, even including the buyback of the shares. If there is no provision for the buyback of the shares in the AOA, if even company law permits, we cannot go for a buyback because there is a mandatory requirement that you should have a provision in the AOA. If it is not there, you are supposed to amend the articles for which you have to call for the general body meetings or the general meetings. So articles of association contains the bylaws for the various aspects of the corporate law. Some of those aspects basically, and in addition to the previous slide, there is again the voting rights and people who can have the right to have the proxy. Then the other one is about the board of directors, then the dividends and the winding up and whatnot. If any one of you see the Companies Bare Act, you will find all these sub-concepts. Share capital in one chapter, lien in one chapter, transfer of shares in one chapter, and transmission is one place, alteration of the capital in another chapters. General meeting is one chapter. These are all written in the company law in the various chapters. However, for each and every chapter which is there in the Companies Act 2013, you are having another rules for the same, that is about the articles of association, right? I am not simply saying that Companies Act is only there's one document in the company law at the incorporation, that is the articles of associations. Once you have an articles of association, you can go for incorporation, you submit. Don't read the articles of associations. Don't read AOA just as a document. That can be done anybody else. You cannot read just it is a document, therefore we are reading, we are submitting to the ROC, then therefore our job is done. No, AOA is one of the document which helps on day-to-day management of the company, which helps if at all there is a bylaw which is something different from the company, which is something in addition to the Companies Act, you are supposed to read, you are supposed to understand each and every principle of the corporate laws. So AOA is the primary most document. At the time of incorporation, AOA has to be prepared, and here the important concept is that the people who are managing the company, the people who are doing the management of the company, or otherwise the promoters of the company, are given the freedom, and the freedom what they have given is that the management or the promoters of the company, they can draft their internal regulations, right? They can draft their internal regulations. So the point is that there are two regulations which comes to govern the company. One, you have the Companies Act 2013. Other one is about the articles of associations. So keep this in the mind, because articles of association forms part and parcel of the law. The people, whoever is approaching to the company, by reading the articles of association, it will have effect as equivalent to the legal law. And the clauses of the articles of association, right? The provisions of articles association can be a subject matter, right? Can be a subject matter before the court of law. So try to remember these concepts. It is not the simple we are reading. AOA is a document, you will submit to the ROC, you will incorporate the companies. So therefore the AOA has a something which is more than what we read, just a piece of paper, just a piece of law which you are submitting before the court. Now, as I just told well in advance, you may say that how it is having the legal impact like the provisions of law. So section 10 of the Companies Act, okay. Now we are moving to the another sections. We are discussing about previously section 4, section 14 and schedule 1, table F, G, H onwards, right? This is what we have studied so far. Now we are moving to another concept, that is about the section 10. Section 10 talks with regard, subject to the provisions of this act, memorandum and articles when registered, they will bind the company, right? This is very important, and binds on the members. That means once you are having the company, if it is being registered, because without the registration of the AOA, the company will not come. The point here is that in the AOA, you should have the clauses. So please remember this one. You cannot say that, sir, AOA is being registered, then you have the provisions of the AOA, then the law is being done. Here let me take one of the famous scam or a case which came into the public domain, and the public domain cases was the one of the famous case was the Satyam scam. When the Satyam scam was discussing, and the Mr. Ramalinga Raju was the managing director, was willing to go for the buyback of the shares, right? It was a story of 2007 I am talking, not now, in 2007 and 2008. When the management of the Satyam company tried to go for the buyback of the shares, and they called and they tried to go back to the buyback of the shares, and when the buyback was supposed to happen, and they found that there was no provision, right? There was no provision in the AOA. Then Mr. Ramalinga Raju called for, right? He called for the meeting of the extraordinary general meeting, that is one the board of the directors meeting. So he called for the board of directors meeting in those years, and the board of directors meeting was called. Then the people came to know there was some problem in the accountancy, that is a separate issue. When he was being punished by the court, and one of the statements of Mr. Ramalinga Raju was that he paid almost all rupees 120 plus crores, right? He paid the money of totally 120 plus crores of rupees to the legal team, not 1 or 2 rupees. The Satyam company paid to the legal as well as to the accountancy team more than 120 plus crores, and even after collection of the 120 plus crores of money, the company failed to draft a proper articles of association. So this is what one of his interviews were there. If anybody wants, they can go back and see the old newspapers. Because they thought there would not be any requirements, therefore you don't require to have the AOA, and the clauses were not there. So AOA has so much of importance where you go to the court of law, fight for the clauses. Let me take one of the recent cases where there's a lot of discussion is happening about the questioning about the provisions of articles. Now here I just put it one of the case, Tata Consultancy Service Limited versus Cyrus Investments Private Limited, Manu Supreme Court 2021. Here they are talking Article 75 Clause 3, right? Article 75 Clause 3 is the question and subject matter in this particular Tata Consultancy Group. Majority of you may be knowing that we are not going to the personal issues of any company or the managing directors. When the late Tata Group's chairman, Tata Mistry, he was contesting and fighting for the appointment of director's post, the issue came before the court of law invoking the provision of Article 75 Clause 3 of the, right? Article 75 Clause 3 of the Articles of Association. Here they are asking about the restrictions on the right to invoke on 75 Clause 3, restraining the respondent number 11 and the nominee directors in advance, and setting aside the conversion of the appellant into a private company. So here the issues were brought, how the Tata Consultancy Group or the Cyrus Investments Private Limited, because here the respondent is the Cyrus Group, right? Respondent is the Cyrus and appellant is the Tata. Tata brought the group against Cyrus, stating that the respondent have no right, and this case was discussed elaborately. One of the provision is the Article 75 of the Articles of Association, where they have the tinkering with the powers available under the Supreme Court before the Supreme Court, right? So my point here is that reading of Articles of Association just for the sake of a single document, right? You are incorporating a company and the company brings the articles and you submit to ROC, the company came to the existence. It is as simple as that. And what is the practical life, the practical aspects of the AOA, which you are supposed to understand, and where the cases comes in the practical, on the day-to-day basis of the practice. Because today one of the landmark case which we see, Tata Consultancy Service Limited and Cyrus Investments Private Limited, where the citation is given here, Manu Supreme Court 02/27/2021. In this case, the issues were discussed on Article 75 of the AOA, whether they can enforceable or not, and the contradictory came with regard to the Section 241 of the Companies Act, that is on oppression and mismanagements. Now my point in the initially this class is that the AOA becomes one of the fundamental legal document. Then AOA has lot of implications to understand. It is not a simple document which you just submit before ROC and forget your lifetime. AOA has the importance like any other documents. Therefore, try to remember the importance of AOA, how it comes, how as a lawyer, how as a company secretary, how as a chartered accountant, you are supposed to read the AOA. If at all there is no clause, then how you can amend, and how the rights arising out of the articles of associations. Kindly remember this concept, which is very, very important. Then another concept in the articles of association is the doctrine of constructive notice. This is the another very important concept. That means this doctrine is a principle, a presumption of the knowledge and relevant in the company law, as we know that it is mandatory for every company to get registered AOA MOA, and AOA MOA register of companies being in the public office, the registration of these two documents are public documents. That means MOA, AOA of the company are submitted to the registrar, so therefore they are the public documents. Any persons dealing with the company, right? Any person is dealing with the company, it is a presumption they have read and understood the true meaning of these two documents. That means if any person, like for example, A is entering into a contract, right? A is entering with a contract with X Limited. The understanding of the X Limited is that A read, right? A read already MOA and AOA. So that is a presumption that under the principle of doctrine of constructive notice, the people who are approaching the company, right? The people who are approaching the company, the people who are dealing with the company, right? The people who are dealing with the company, right? The people who are dealing with the company have read the documents of MOA and the AOA. That means these are the public documents. That is why they use the English terminology. They will fall under the definition of not only a notice, it is called as a constructive notice. What is meant by constructive notice? That means though they are not informed to everybody on daily basis, the presumption is that the people who are approaching or the dealing with the corporations, they have read the MOA and the AOA, and they also understood the proper true meaning. So once you understand the true meaning, then you can deal with the company in various transactions, right? So this is what we call it as doctrine of constructive notice. Let me recapitulate what we have discussed just last 15 minutes, right? So we started the discussion that the importance of articles of association, which is the primary document, which has to be submitted to the ROC at the time of incorporation of the company and followed by other documents, that is the MOA. And Section 4 of the Companies Act speaks AOA is equivalent to the any legal document. AOA talks about the articles of association, talks about the rules on the management of company, otherwise called about the management rules. And AOA, you are having the principles which are given under the table F, G, H, I, J. It's up to the companies which they can adopt. Then section 14 of the Act talks about that the alteration of the articles. So because once you drop the articles, if at any point of time you wish to change the articles, so you have a right to change out. So it is given to you in the section 14 of the Companies Act. Then this particular page which you are able to see talks about various sub-clauses. These are all the sub-themes which you will find under the tables, right? When you look about the table which is available to you in company law, you will find all these concepts in a different and elaborative paragraphs. So it is given to all of you how to draft in what part of these sub-themes or sub-concepts you can incorporate. And moving further, we also talked about section 10. So now in brief, articles of association comes under the two important way, section 10, section 4, section 14 and schedule 1, right? Section 4, section 14, section 10 and the schedule 1 are the basic concepts of the articles of association which has the legal implications apart from the schedule 1 of the Companies Act. Then I also referred two examples. One is the Satyam's case where there was no provision in articles of association, because of which the advantage which came in the public domain about the Satyam scam and the management where they paid hundreds of crores for the team of accountants and lawyers and auditors. Somehow they have forgot to write. That was an allegation made by the Mr. Lamaringarazu. There was no provision in the buyback, therefore he has to amend the provision in the buyback that came. And the recent case in 2021, Tata Consultants versus Cyrus Mistress, Supreme Court judgment. The question before the court was that the impact and interpretation of Article 75 Clause 3 of the Articles of Association, which gives the rights to one of the parties. So this question is again elaborately dealt. If anyone is interested to understand the subject, I have given a citation here, Manu SC 0227 and 2021. You can read, you can understand. Or if I am coming to another lecture in the future, other class on the operation mismanagement, we can discuss this case elaborately. However, I brought this case even to introduce to you on the aspects of how the articles of association or the clauses of articles of association become the part and parcel of a legal right, the legal right which came before the Supreme Court, and the people approaches the Supreme Court to enforcement of these legal rights. Now the another concept which comes by virtue of MOA, AOA is the concept of constructive notice. So it is a concept which is a presumption and the presume that the people who are approaching or the persons who are approaching the company, they read the document, and after reading of this document and it is being understood that they are having the proper informed judgments. So here actually there is a rider. Please remember, whoever is doing or whoever is working with the corporations, they should have some understanding. We use in a common man language called as the financial literature understanding, like, or how the people can understand the language of corporate law. So if they are not understanding, they can take the help of the experts. But in the eye of law, right? In the eye of law, the people who are dealing with the companies, they have read these documents, MOA and AOA. Presumption is that they understood these concepts very well. One of the landmark case was Ashbury Railway Carriage and Iron Company Limited versus Ritchie. It was a company's contract to finance Ritchie for laying down the tracks in Belgium is ultra-virus, that is null and void, because the memorandum of the association of the company contained object of making, selling, hiring railway carriages and wagons, mechanical engineers and general contracts. It never mentioned about the financing of contract. This particular case will come to you in very frequently in various concepts. One is about the ultra virus and the constructive notice, right? As well as other ones. Now what happened here is that a company was formed for the purposes of making, selling, hiring of railway carriages, wagons and mechanical engineerings. However, this company entered into a contract for the finances, contract of finance or contract to finance. The question was that whether this company is competent enough to enter into a contract to finance, which was not permitted by law. And the court held that this comes as an ultra virus, though there is no power, right? Though there is no power given under MOA, because it comes about the beyond object clause, then it cannot be questioned and the contract cannot be implemented. The company knowingly enter into a contract even though they don't have the power. And they also brought another concept here. The other respondent which says Ritchie didn't get a compensation because of the doctrine of constructive notice. Because the people who have entered a contract, they know that this has already in the public domain, because MOA is available, AOA is available, then people should have read and enter into a contract. Knowingly, both the parties enter into a contract and one of the parties disputing that for enforcement of the contract or the dispute as such. Company is aware that it has no power and the other party is aware it has also the company has no power. So that means in MOA the company was prescribed only to do certain activities. Those activities are contained in the objects of making, selling and hiring of railway carriages and wagons, mechanical engineering. It has never specified that company can enter into a contract to finance. So a thing which is not permitted, a activity which has not been permitted by virtue of law, if these are being entered, it can be called as doctrine of ultra virus and it cannot be interpreted and implemented before the court of law. So it's very fascinating case, because to discuss about the Ashbury Railway Carriage and Iron Company Limited, we require another 2 more hours. Because any judgments given by the United Kingdom courts, you have always separate opinions, dissenting opinions. So it's almost very interesting. Now there is one more point try to remember. It is a case of 1875. We are reading in the 2022. What is the carry from 1875 to 2022? So almost all 200 years completed. Still whether it has any relevance. A judgment which was given 200 years back by a foreign country, how it is relevant today? The relevance is that the principle of constructive notice and the ultra virus. So kindly remember, though the case and facts may be different, the principles which are existing from 1875 to 2022, right? What are the concepts which are existing from 1875 to 2022 are that MOA is existing, AOA is existing for the incorporation of companies. So there the fundamental principle is that since MOA and AOA, which is a document existing from the beginning to right now, so therefore it has a legal implications. The people who are approaching the company and entering into a contract, the understanding is that it falls under the definitions of constructive notice. Beyond that, it goes under the principle of doctrine of ultra vires. Now, in a brief of these lectures, I tried to explain the importance document for incorporation, that is articles of association, right? We have discussed section 4, 10, 14 and schedule 1, which forms part of the articles of association. Articles of association is a very important document for the incorporation of company. Articles of association is almost all the life of the company, how the company has to be functioned. So therefore, the primary document which you are drafting and submitting to registrar at the time of incorporation, be very careful. Write your questions, write your what you can say concepts, write the rules, regulations, as well as the rights, which we call about the rights with regard to the rights, rules, how the company has to be managed very meticulously. This is where I am pausing my lecture up for the day. Maybe this is the third lecture which I tried to introduce. Initially intro, then corporate law, documents, MOA and AOA. In the next lecture which I am going to upload, we will be talking about the concept of lifting of corporate law. The next lecture will be on the lifting of the veil. So I request all of you, listen patiently, understand the subject, kindly provide your feedbacks and comments, and take care. Bye.